Apostle Mwabiru, thank you very much for hosting us. Judge Nyachai, Professor Lumumba, esteemed colleagues, I'm extremely delighted to be here today to celebrate with you the 2010 Constitution. I think I want to start very briefly from the conversation or the talking down that SG Ogeto was making in his submissions before the Court of Appeal, his opening statement in relation especially to the use of Wikipedia as a source of a definition of popular initiative. A conversation that I think has continued when you look at the judgment or the opinion of Judge Okwengu in the Court of Appeal decision. In talking down or speaking down to sort of Wikipedia, what Ogeto was doing, in a sense, was looking down at the idea of common, of a global common as a source of legitimate knowledge. The whole idea of looking down upon common property, our commons, our African commons, as worthy of protection or as worthy of fidelity. My engagements in the context of the Constitution really were focused precisely on some of those challenges. The challenge of protecting marginalized communities whose vision and whose version of property did not necessarily comport with the mainstream version, which is individualized property that is evidenced by way of title. And so what we were successful in doing through the 2010 Constitution is the recognition not only of the identity of marginalized communities, and the embedding of their rights in the context of Article 56, but more than that, the recognition of their viewpoint in relation to land and property, in Article 63, the recognition of community land tenure. I want to submit, Judge Nyachai and Professor Lumumba and colleagues, that if there is a domain of the Constitution that continues to want for implementation, that continues to crave deep and sustained work, it is in this area of deconstructing our property relations, because it goes to the very heart of the livelihoods and the survival of our people and our communities, especially those who are most downtrodden. I say this because notwithstanding the existence of these frameworks and these parameters, I think we have continued to witness over the last 11 years such flagrant violations of human rights that these communities face. And I think we have all witnessed the gross levels and the indignified manner in which communities have been evicted. I don't have to go all the way to Emberwood Forest or to Mao Forest, but even right not far from here, in Kibra, in Mukuru Kwaroben, in Mukuru Kwanjenga, these are communities that continue to live in our country, but they continue to live as if the 2010 Constitution is not relevant to their lived reality. And so while we may and we should and we must extol the achievements that we have made thus far, I think there is still so much work to be done. And while we continue to celebrate what has been achieved, especially through our progressive judiciary, the kind of jurisprudence that has emerged, I think when you look at the jurisprudence in relation to land, I think you see actually a deep and concerning retrogression. I mean, if you study keenly the jurisprudence of the Supreme Court in the National Land Commission matter, when you compare that with the jurisprudence of the same, Supreme Court in, the re-speaker of the Senate matter, you can clearly see a dissonance and a reluctance, on the part of the judiciary to really engage, with these relations and to begin to use the transformative provisions of the Constitution to deconstruct our land and property relations. But because I've been given only a very short time, I want to end by saying that aside from what has been submitted very ably, I think the other issue that we must be concerned about is this whole idea of institutional capture. You envisioned, I call you the fathers of the 2010 Constitution, you envisioned the existence of independent commissions as carriers and protectors and safeguarders of our sovereignty, or the people's sovereignty. But regrettably, when you look at the performance of our commissions, very few of them, I must say, inspire confidence. I think today, it is so easy for human rights violations to be perpetrated, gross, massive violations of human rights to be perpetrated without a word from the so-called National Commission on Human Rights. Despite its robust mandate, today it is so easy for there to be a failure of gender justice, notwithstanding the existence of the Gender and Equality Commission. Today, land grabbing is alive and well by other means, notwithstanding a robust commission, the so-called National Land Commission. And so there is a lot of work that remains to be done. But I take courage and I take confidence in seeing ordinary citizens represented, I think more recently, by the person of Oluchier, whose advocacy before the High Court and the Court of Appeal, especially in the BBI matter, and especially touching on the question of presidential immunity, was so canvassed and dramatized before the entire nation. It is citizens like Oluchier who will remain vanguards and protectors of our constitutional order. And so, ladies and gentlemen, I really stand here to say thank you very much for the work that you do, the contribution you have made, and the work that you still have to do. Thank you very much, and God bless you.